This is case number 24-1080. It's Christian Marin versus Nemours Children's Hospital, AKA the Nemours Foundation. Counsel for Mr. Marin. Ms. Arago, you can approach the podium. Typically, the rebuttal is 5 minutes, but I can add more or less if you like.
5 minutes, I think, will be appropriate.
Whenever you'd like to start, ma'am.
May it please the court. My name is Maureen Arago. I'm the attorney for Mr. Marin. I think the microphone is working.
I'm going to stop you for a second because my microphone is working. Is yours?
Can you hear me?
I can hear you. Can
Okay,
people in the
thank you.
back hear her? A little bit?
Hello?
No problem.
May it please the court.
How are we doing in the back again? Better? All right, thank you.
My name is Maureen Arago, and I represent Mr. Marin, who is the appellant in this matter. The court should reverse the final order by the Florida Commission on Human Relations, which dismissed Mr. Marin's petition for relief from a discriminatory employment practice. The denial of Mr. Marin's request for a religious exemption from taking the COVID-19 vaccine violated the Florida Civil Rights Act. The Florida Civil Rights Act of 1992 prohibits discrimination in the workplace. It's modeled after Title VII of the Federal Act, and both parties have asserted that case law applicable to Chapter 7 informs decisions regarding the Florida Civil Rights Act.
Is there anything that says EEOC guidance applicable to Title VII is applicable to the FCRA?
I think it would be because case law has considered EEOC guidance in making their decisions. I'm not aware of any Supreme Court, U.S. Supreme Court decisions that have referenced the EEOC guidance, which is the primary authority, but I think it would be in applying other decisions who have considered EEOC guidance.
Have any Florida courts referenced EEOC guidance on Title VII? The reason I mention is because that EEOC guidance, that they cite says you can consider the hardship of, collectively, right, of granting a certain number of employees. And I think that's a really different question than whether giving Mr. Marin an exemption would have posed a hardship. That guidance to me seems important, to the extent it was to be considered.
I agree with you. And I think that in this case, though, there were 170 exemptions that were granted. Nemours has admitted that it would have granted the exceptions, but for different purposes in the request. And so I don't think Nemours can rely on undue burden based on the excess number of exemptions.
But doesn't that kind of depend on, so those 170 that were granted, we don't know what they were granted for.
Correct.
Right? And so you could have 170 different reasons.
Correct.
Right?
And we also don't know where those employees were located. Nemours granted the exceptions. The Religious Exemption Committee considered the exceptions on a blind basis. Therefore, they had nothing to do with determining undue burden. The guidance to them did not limit or to give a certain number of exemptions that they needed to grant.
But what I'm saying, the question of, well, they granted some and they didn't grant his, and therefore they can't claim a hardship. That if the guidance is right, that you can consider collective hardship in the aggregate, then it would be a very different question to me, the first 170, if they had 170 different reasons, and then 170 that all had the same reason. Because each one of the first 170 is only going to cause one person's worth of hardship.
Correct.
But this other reason is going to cause 170
Correct.
Persons worth of hardship.
But Nemours never said that they used that as a basis for denying the exemptions. The guidance that was given to the committee specifically did not say they needed to deny these 100 exemptions that were denied based on the connection to abortion and fetal stem cells. These are the ones that Nemours decided the connection was too remote. Connection is actually a word that in the case law, the Lee versus Artis Naples case that was cited by the administrative law judge, it was cited by Appellee's brief as a part of the authority for the decision-making, has a footnote in its article, footnote 3, where they discussed some of the cases that denied and some of the cases that found religious exemptions. One of the things that they found was the bizarre nature of looking into the reasons behind the religious exemptions. They used the specific word connect. So they found it was bizarre that they attempted to try to connect the reason for the objection to the religious belief. And in this case, that's exactly what happened.
But isn't that kind of going to, and I hear everything you're saying, but that kind of goes to step one of the analysis, right? Which is like,
Correct.
should they have found a genuine conflict? It doesn't really go to the second step, which is just the hardship analysis
Right.
of, if you're correct on step one, that they shouldn't have questioned the nature of his belief and that they shouldn't have basically interpreted his own statement against him, right? Just purely the hardship question. It seems to me that if the EEOC guidance is something that could be considered or should be given some kind of deference to, that the collective hardship, the fact that there was 170 based on one reason would be relevant. Whereas if the EEOC guidance is not something we should look at, it shouldn't.
No, I think that the EEOC guidance is something that should be looked at. But I think that in this case, as I said again, they didn't use that basis, that collective figure as the basis. All the admissions were that a specific number was not given to the committee to grant or deny. Also because they were blind exemptions. If you look back at the case law.
Ms. Arago, if I could interrupt on that, because you've mentioned this a couple of times. Has the U.S. Supreme Court stated that the undue hardship rationale must be articulated before the adverse employment action is taken and must be the same as what's brought up as an affirmative defense in any litigation?
No, Your Honor, I'm not aware of that being the case. But
So would you agree then the appellee was not limited at the Florida Commission or here to the articulated undue hardship?
No, I would agree with that. I think that they are permitted to show the undue hardship at the later stage, but I don't think that they have.
I have undue hardship questions, but before I ask those, or before anybody asks those, let me go back to that first step. Do I understand your position that an employer can never question the connection between an employee's stated religious beliefs and the actual what they're grounded in factually?
I think it's essentially yes. I think that they cannot. The two particular cases that are cited in this case, the Bordeaux and the Together employees, both of them talk about the narrow function of the courts is to consider whether the belief is sincerely held, to not delve into the reasons behind the belief. There are no cases.
Does sincerely held presuppose factually correct, though? And I will recognize that perhaps this case isn't the easiest one to talk about factually as it relates to my question. But imagine a situation where, for whatever reason, the situation was that the employee could only eat in the employer's kitchen. Couldn't bring in outside food, call it security reasons, remoteness of the location. It's the joy of a hypothetical, right? So the employee says, I cannot eat in this kitchen because it's not kosher. The food isn't prepared in accordance with my religion. Evidence shows across the board, we're past the motion to dismiss stage, say we're at summary judgment or trial. Evidence shows that it is 100% absolutely a kosher kitchen. Is it your position that the employer would still have to accommodate in that situation?
I think in that situation, if the employee took the employer's religious beliefs seriously and then entered into an interactive process, which would be part of the accommodation process that is required by the courts, then I think they would have been able to tell the employee, well, in this case, which is not a kosher kitchen, is this then still in violation of your religious
That's
belief?
not the question he asked you. It's not the idea of accommodation. If he says, I don't believe, I can only eat kosher food, that's my belief, it's religiously objectionable to eat non-kosher food, and the kitchen is run, not just in a certified kosher way, but in the exact way the employee says the food needs to be run. If he says, my religious beliefs require the food to be prepared this way, and the employer says, great, because that's exactly how we prepare it. There's no conflict to
Right.
accommodate, right?
Exactly, because I think then you have accommodated the conflict by providing the kosher kitchen. In
Have you
this case,
accommodated the conflict, or have you
Yes.
just established there never was a conflict?
well, in this case, I think that that's part of what Nemours has tried to argue. They've tried to go in and do a fact-based analysis of what the client
I'm
has,
just trying,
the employer.
and I hate
has
interrupting,
illustrated.
I hate
Yes.
interrupting lawyers,
That's
but I
okay.
think what we're both trying to get at is, can you acknowledge that there is at least some case out there where we wouldn't have to get to the accommodation stage? Or are you saying that the accommodation stage would be explaining that they're wrong?
Oh, definitely there can be a case that wouldn't get to the accommodation stage if it was based on the genuine religious belief. And I think that's where sometimes they can
What
go
about
back to the
what about the
fact.
hypothetical, though? What about the fact pattern that you could demonstrably disprove it? And we can do other things.
Right.
If the religious belief was that for whatever reason, the sun rotated around the earth. We know we have the ability to disprove that scientifically today in ways that maybe we can't disprove other things. I'm just trying to get you to, and it's not conceding a position in your case necessarily. I just want to know whether we're talking off of the same sheet of music.
Yes, because I have not found any cases that allowed the fact checking. And the courts have warned against that. And in the cases, the Bordeaux and the Together employee cases that I cited, they said that essentially once the employee has asserted or alleged the conflict, they've pled their prima facie case in that respect.
And it seems
that-
like in that case that there's no, it's the easiest prima facie case in the world to prove always.
It
You
could
just
be.
say, I have a religious belief, no matter what it is. The sun revolves around the earth, the kitchen isn't kosher. Then all of a sudden, you've established a Title VII and an FCRA claim. I
Well,
struggle with how that can be true.
Because then you could go to the genuineness. I think then regarding the genuineness, perhaps in that case, that's what you can test the genuineness with objective facts. So if you said, we've got this kosher kitchen, this religious belief can't really be genuine because this kitchen is kosher. And if you can ask them questions like that, I think that could.
It doesn't have anything to do with whether his belief is genuine. It has to do with whether his belief conflicts with the employee policy.
Right.
I mean, take the example of, I think in their brief, right? The policy is you have to work Monday through Friday. And the person says, I have a genuinely held religious belief that I can't work on Sunday. They're not questioning his belief in any way, shape, or form to say, okay, well, Monday through Friday isn't Sunday.
Right, and that's where I think you've fallen into the accommodation part, which was then, it's not that your religious belief isn't genuine, but we have accommodated it because we're not requiring you to work on Sunday.
But they didn't accommodate it. They established a lot. You don't need an accommodation unless there's a conflict.
Right, and so there was no conflict because of the desire to work on Wednesday.
I understand that. I understand that. I understand that you're
And the
not.
courts have.
If
and
I
the-
might.
Uh-huh.
I understand that you're not going to concede that point, and that's fine. As it relates to your particular facts, your client's particular factual situation, did the administrative law judge make a finding in the recommended order that was adopted by the commission relating to whether or not HEK 293 cells were used at all in the Moderna and Pfizer vaccines?
No, she didn't.
Does the
She-
failure of the administrative law judge to make that finding that the FCRA then didn't have a chance to adopt the specific factual finding, does that give you challenges as it relates to your ability to challenge that missing fact? Because I think your brief presumes that it's so.
Right.
And certainly there is some record support that it's so. But does the failure to make a finding or your failure to ask the administrative law judge to make that finding when she didn't do it, does that harm your appeal?
No, the administrative law judge specifically said that the vaccine was the connection was too tenuous because it said she used some language that it was used to manufacture, produce, or she referenced only, the cell line was only used in the early stages, something like that. But then she eliminated from the finding where she talked about the cells were only used to manufacture or produce. But then she referenced back to, I believe it was Mr. Carpenter's testimony, where he said that the reason for the creation of the category of exemptions to be denied was because the connection was too
Nemours
remote.
itself determined that abortion-derived materials were used in preclinical testing.
Correct.
So they didn't contest that they were used in the process of developing the vaccine. I think Nemours' contention was that the vaccine itself that you're injecting into someone's arm does not contain that. It was limited to the testing phase.
Correct.
It does not actually contain anything. The vaccine put into your arm does not actually contain anything derived from abortion. But
Correct.
nobody contested. Nemours determined itself the vaccines were developed using abortion-derived materials, correct?
Correct. And that's part of the issue. We believe that Nemours essentially is basically a religious decision. They decided that the use of the fetal stem cells was ubiquitous. They presented that material to the committee, which was basically material derived from a priest blot. And they said, therefore, the religious conflict would be too remote. So I think basically they made a religious decision that the vaccine connection was, and that's what the word that they used, that the administrative law judge used, that was Mr. Carpenter's phrase, that there just wasn't enough of a connection.
So the key issue to me, I'll be honest, you make two arguments in your brief. And the first one is they couldn't question his assertion that there's a conflict. And I'll be honest, I think that's just obviously wrong. And I think you've seen that was not a good argument to make, okay? But the second argument you make, I think, is a lot more interesting, which is that the way they interpreted his own statement against him, right? So he said in his statement, I think he said, I have a deep religious objection to, taking any vaccines that were made using abortion-derived materials. And so the question then comes how to interpret that statement, how to interpret the employee's own statement of his belief. And Nemours interpreted it pretty narrowly. And they said, well, he doesn't want vaccines made using abortion. Made really means manufactured to where it physically actually has abortion-derived materials in what's shooting into his arm. And these vaccines don't, therefore there's not a conflict. Whereas he's interpreting his own statement as made means in any way used in the process, in any way related to abortion. He has a broader interpretation. And so, the parties kind of use some dictionary definitions in their briefs to elucidate the meaning of his statement. But I think really the kind of fundamental question here that isn't really perfectly fleshed out in the case law is, what is the once an employee has given a statement of his belief, sometimes it's obvious. I don't want to work on Sundays. Employer says work on Wednesdays. There's no interpreting to do there. But when an employee's statement is not perfectly clear, or at least both sides don't agree that it's perfectly clear, what is the mechanism by which you interpret the employee's statement of his own belief? It would seem to me that in a situation where the Nemours and the ALJ kind of interpreted it against the drafter, right? They basically said, well, we're going to take the benefit of the doubt away from you. Whereas in a situation where the entire, issue is, does it violate his own personally held belief? It seems to me you would interpret his belief kind of in favor of the drafter, since the whole issue is whether it violates his belief. Can you address that?
I agree with you, Your Honor. I think the civil rights statute is to protect the employee. And here you have an HVAC mechanic who has basically expressed his sincerely felt religious beliefs. And he's expressed them using the form that came from Nemours, which had that odd breakdown of the 4 factors, which said the fourth, in fact, needs to conflict with the religious belief, which is not what the EEOC recommendations would be or anything like that. Mr. Marin, as an employee, an HVAC mechanic, then he sends in his application, And then Nemours gets a body of lawyers and doctors and other people who then look at it and tear it apart and try to find a reason, it appears to deny it by basically putting in the category of with the 100 people
Counsel,
who
did
they
the
choose
ALJ
to
make a
deny.
finding that Nemours got lawyers and doctors together with the intent to find a way to deny it? Is that
No,
finding made?
I don't think that they said that they had an intent to find it. But I do think that the administrative law judge did find that they sought the assistance of the lawyers and advisors to decide how to look at the applications.
Is there
And-
any law that goes in a more fundamental way into how to interpret the employee's own statement of their belief? If there's a deadline, hey, by September 1st, tell us if you have an objection. And then that deadline passes and they've submitted an objection, now it's on a piece of paper, and they have different interpretations of what it means.
In most of the cases, many of the cases, if you go back and forth, they actually do have an engagement with the employees to find out, and to find out where they work, how they can accommodate them, what they can do. That didn't happen here. But I think also the fact that the body of cases is you take the employee at his word. And the federal court cases, some of the local cases, particularly, I believe it was the Together employer, the Bordeaux case, where they went back and they cited Supreme Court law like Thomas, and where they said, take it for granted that this is the employee's belief. For example, the case where the employee was fired where he didn't want to build the military equipment. And they said, well, you were willing to work on the parts of the military equipment. Why aren't you willing to work on the military equipment? And the court said, you can't make that distinction. That's outside the purview of the court.
Let me ask, and I realize that we have you over time, but it's an interesting case. Counsel, we'll give you extra time if you need it, to be fair. Let me ask that undue hardship question. We've got this 2023 U.S. Supreme Court case, DeJoy, which talks about the burden, and it says the employer must show that a burden of granting accommodation would result in substantial increased costs in relation to the conduct of its particular business. It also suggests that this is a case-by-case analysis, it's an industry-specific analysis, and that trial courts are the people to do it as the best as a matter of first instance. There's some argument in your brief as it relates to the failure of Nemours to articulate specific cost in dollars and cents as it relates to the impact of your client not being able to go. Let me ask you a couple undue burden questions. Under DeJoy, are we limited to dollars and cents?
No, Your Honor, but that's part of
Secondly,
it.
how do we look at the specific nature of this business? Children's Hospital with severely immunocompromised children, and presumably one section of the hospital, children who actually have severe COVID complications, and the other side of the hospital, and the notion that your client is an HVAC technician who goes into these people's rooms regularly. And it's a handful of times per week, so I'm
Correct.
hearing up to 5 times per week, which to me is regularly.
Yeah, and with no direct contact.
Well,
And-
all that means is that you're going into the patient's room where the patient is severely compromised and you're not directly interacting with the patient. It doesn't mean that you aren't in the patient's room with the patient. So how do we look at that from an undue burden perspective as a court of review, as it relates to this specific industry, as say if your client was working at an Amazon warehouse?
Right. And Your Honor, I think that a couple of the courts are very informative in this regard in the health cases. And I'll go again to the Morissette case, let me see.
I found one case as it related, and one case only as it related to children's hospitals with immunocompromised children. And
Well-
that was the St. Jude's Hospital case, which isn't read favorably as it relates to your client. I'm wondering, and without relying on the case law, because district court case law throughout the country doesn't bind us, how would you just answer that question as to how we look at your client in this particular scenario, if that is indeed what we look at?
Yes, I think in this particular case, I think that the fact that there were exemptions, they offered the religious exemptions, indicates that accommodations could be made in some respects. The fact that they made 170 accommodations indicates accommodations could be made in some respects. That they could talk with Mr. Marin and say, is there a way to keep the patient safe? The testimony was that throughout the pandemic, the patients had been kept safe even before the vaccination program began. The testimony was also that the employees, each of the employees have been kept safe from each other. The only concern that Dr. Alexander had was that employees could get sick outside and then miss days at work. So there was no testimony of concern for the patients.
I don't think
And
that's an
then-
accurate statement.
I believe that
Dr.
is.
Alexander said he was concerned about employee-to-patient infection and employee-to-employee infection. Now, we can have a separate discussion as to whether or not that was a hypothetical concern.
Yeah.
But he did testify that he had that
Well,
concern.
he testified that they had had no incidents of employee-to-employee
That's
or
fair.
employee-to-patient. And so there may have been some speculative testimony that I don't recall.
In other words,
But-
is he entitled to say, our data shows it's not a concern, but I still have the concern? Is
He
that
could
competent,
say-
substantial evidence? Because that's basically what he testified to.
He may, if that's what he testified, he could do, but I would not believe that that then would have met the undue burden standard.
Nemours basically said, we didn't do individualized analysis of each of these employees. It was all anonymous.
Correct.
And it seems to me that, are they really able to hide behind that in terms of showing the undue burden? Because it seems like if you have two brain surgeons at a hospital and one or two of them are out because of COVID, that's an enormous undue burden. With your client, we don't even know the nature of the HVAC repair. I assume HVACs are not breaking every single day of the week. Are we talking routine HVAC maintenance that could wait a couple of weeks if he gets sick?
Exactly.
Right, so
Your
it's,
Honor.
there was really, it wasn't just a lack of dollar and cents. Other than saying like, it would be hard for us to have a disruptive workforce, other than kind of the bare assertion, I didn't see any, articulation of the specifics of, hey, here's how many employees we'd be out. We wouldn't be able to cover those employees, right? I didn't see anything on a global level as to specifics, even outside of dollar and cents. And I certainly didn't see anything as to your client in terms of, hey, we've only got one HVAC repair guy, and if an HVAC repairs, somebody could die. If an HVAC breaks and he's not there, somebody could die, right?
Exactly.
That's very different than, well, we've got 4 HVAC repair guys, and 95% of the time they're doing routine maintenance. That could easily wait a week, or we could just pay one of the other guys a little overtime. Those seem to me to be completely different scenarios, and to say that we didn't do an individualized analysis, can you get out of an obligation to show undue hardship just by declining to do an individualized analysis?
I don't believe so, Your Honor. And I think that's part of our argument. All of the people, the 170 they granted, they might not even been in Mr. Marin's hospital. We don't have any of the data. They didn't provide any data for that.
Let me ask you this, do you think the scenarios would be very different, for instance, if your client is the only HVAC guy, and they have patients that if their HVAC breaks because they have temperature issues or whatever, they will die,
Yes.
or versus they have 6 HVAC guys, and they spend most of their time doing routine maintenance, and maybe once every year something breaks and one of them has to fix it, but that maintenance could wait 2 weeks and no one will be affected. Those are drastically different scenarios, right?
They are, Your Honor, and I think also then, besides the ultimate conclusion, where then that might have been appropriate to find an undue burden,
Yeah.
they would have taken those steps to attempt the accommodation,
Yeah.
which goes back to number 2 of the issues where they really didn't attempt an accommodation and then declared that the fact that he could take the 2 vaccines that used testing but didn't have the fetal cells within them, that would have not violated his
You can
religious
see under the
belief.
first scenario where the HVAC guy, if he's gone, kids die, Nemours probably wins, right?
Yes.
And under the second scenario where we have 6 HVAC guys and it's mostly routine maintenance, your client probably wins.
I think
right?
so. If
Who's
they have, if they had not done an accommodation to see if maybe there was something else they could
But at least in
put
terms
on.
of showing undue hardship.
Yes.
There's no undue
They
hardship.
got to that
right?
point, yes.
Yeah. Whose burden was it to show undue hardship?
It was theirs. And that's clear under the law.
Any other questions?
All right, thank you.
Thank you, Your Honors.
May it please the court, My name is MC Cravata. I'm from Foley and Larner, and I represent the Nemours Foundation, the appellee in this matter. I'll posit to your honors that in some way this case feels very modern, very of the 2020s in its fact pattern, but the law here is well-traveled and well-established with respect to both of the issues raised by Mr. Marin on appeal. First, of course, is the question of whether Nemours impermissibly questioned the validity of his religious belief as articulated on his religious exemption form. The answer is unequivocally no. The record is clear. Every member of the Religious Exemption Committee that testified clearly that they did not doubt either the sincerity of his expressed belief or the religious nature of his expressed belief.
Address the interpretation question, because I didn't see this really well fleshed out in the case law, right? You've got a deadline, you've given him to state the exemption. He meets the deadline, he states it, right? So now you've got a piece of paper with 4 corners saying what his exemption was. And I agree, if it was something totally unrelated of, I don't want to work on Sundays and you want him to work on Wednesdays, clearly your client can look and just say there's no conflict there, right? I agree with that.
Sure,
But when there's some ambiguity in his statement, what is the standard? Because I think, what is the standard by which you interpret someone's own statement? Because it seems like your client interpreted it pretty narrowly, right, in a way that benefited them. I'm sure you would argue that it was, no, we were just interpreting objectively, right? But I'm not even sure there's legal authority for the proposition that you interpreted objectively. I'm not saying there's legal authority for another way. I didn't see it really fleshed out. What is the mechanism? If you have an ambiguous statement that is an employee's own words that they had a deadline to give, do you interpret it for the drafter, against the drafter? Do you try to interpret it objectively? Because I don't think there's any argument that his interpretation is crazy, right? His interpretation is, when I said made using the vaccines, I mean if they use the vaccines in any part of the making. That is not a crazy interpretation. So if you were to interpret it in favor of the drafter, seems like he'd have a very strong argument. If you were to interpret it against the drafter, seems like you have a pretty strong argument.
sure.
We can argue what an objective interpretation. I mean, what is the standard by which we interpret
So
that
2
statement?
points, Your Honor, if I may. First, I disagree that his objection was ambiguous. And something that's important to keep in mind here, employers are not mind readers. And it's incumbent upon each employee who's making a religious accommodation request in any context to specifically well articulate their own belief, right? Keep in mind here the context. The Religious Exemption Committee received over 350 religious exemption forms at a time of great chaos for many employers, but not surprisingly, specifically for a children's hospital. Mr. Marin, his objection is very specific. It says, and this is pages 599 to 602 of the record, he says that he objects to the generation of the vaccine from aborted fetal cells. That's clear. And the definition of generate, it's clear. It means to bring about, right? To cause something to come into being. Now, to answer your second question, your more direct question, courts have answered this. I'll direct your honors to the Gardner-Alfred versus Federal Reserve Bank of New York case from the Southern District of New York, where the court specifically says that whenever you're tasked with determining whether or not there's an actual conflict that's posed between a religious belief and an at-issue employment policy, courts use an objective test. So it's not a test that favors an employee or an employer, it's objective based on the language of the employee's exemption request. And in this case, the language of Mr. Marin's exemption request was clear. And the record is clear, and the ALJ did in fact make findings to this effect, that neither Moderna or Pfizer was generated using fetal cells. And importantly, this is in contrast to the Johnson & Johnson vaccine, which was specifically made or generated using fetal cells. That distinction is important in understanding how the Religious Exemption Committee thought about these issues, and also in understanding the science and understanding what these verbs mean. Words like make versus generate, right? The HEC 293 cells were not necessary to the generation of either Pfizer or Moderna. Those vaccines could exist without that testing. That preclinical laboratory testing was not necessary
I'm
to the
reading his religious
generation of the
exemption,
vaccine.
and it's got more language than you quoted. I mean, it says, upon researching the details surrounding the vaccines and how the vaccines are made, data have shown that the use of aborted fetal cell lines to make. Now, testing is a mandatory part of making a vaccine, is it not? Or is it legal to release a vaccine that has not been tested?
Certainly, vaccines are tested, Your Honor, but there are various ways in which vaccines can be tested. HEC 293
Correct.
cells are an effective way of doing so, but not the only
Oh, okay,
one.
but these ones were tested using
That's
the
correct, Your Honor. We
abortion-derived
don't
materials,
dispute
right?
that.
Okay, you agree. It's stipulated. The vaccines were tested using abortion-derived materials, right?
That's correct.
Are you telling me there's no reasonable general members of the general public who would say they made the vaccines using abortion-derived materials, meaning that to include part of the development process?
I
You think
think-
it's objectively unreasonable?
I think objectively, using the language of the request, I think that make and generate have specific meanings, and I think that the actual portion of his request where he includes his objection uses the verb generate.
Let me ask you this. When we, since you said it's supposed to be objective, when we interpret other types of documents, contract laws, whatever, when there's two different words, we try to give them two different meanings, right?
Generally speaking, yes.
Okay, so you've given me generate. Give me something, a definition of make that would be different than generate, but that your client still wins.
Sure, so to make, at least according to Merriam-Webster, which is probably as good a source of any here, is to bring into being or to cause to exist. And again, the science indicates that the HEC 293 cells did not cause the vaccines to exist.
Are vaccines allowed to be on the market as a vaccine without being tested?
You know, I'll be honest, Your Honor, I am not a vaccine expert, and I understand that these vaccines were developed on a sort of a fast course protocol where the rules of the road may not have necessarily
No,
applied
they were clearly
to a standard
tested, right?
vaccine. Oh, there was pre-component testing, yes.
That was part of the development?
That's correct, we don't contest that.
And you think it is objectively unreasonable for a normal layperson, non-lawyer, to say, well, since they made the vaccines using abortion-derived materials, referring to the whole process? You think
Well,
that that's just crazy and no one would look at it
Again,
that way?
I'll point your honors to the Southern District of New York, who considered this exact question in Gardner versus Alfred. The nature of the objection in that case was that the employee had objected to vaccines on the grounds that they were made or produced using fetal cells. And the court considered the same, sort of same general set of evidence, right, and concluded, no, objectively, that is not true.
There is some record testimony about the origin of HEK 293. And it seems like everybody agrees that it was from an aborted fetus. Is there anything that suggests that it's from an elective abortion versus a spontaneous abortion? And does that matter in this case?
I think that if I'm recalling correctly, it was from a fetus in the Netherlands in the 1970s, and I am not sure that there is a clear answer to your question, and probably you would get different answers depending on which Google search result you click on.
We were all asking questions about undue hardship at the end of your colleague's presentation. Would you address that for us, please?
Sure. So something that's critical when it comes to the question of undue hardship, and this is from both the DeJoy case, but also the sort of Legion's case law that came before, is that the nature of the employee's business matters a lot when we're questioning whether or not there's an undue hardship. And in particular, when there are employers that are in the business of protecting human life, courts should, quote, go slow when it comes to restructuring an employer's practices with respect to the accommodation of religious requests. It is hard to imagine an employer whose interests should be respected more than Nemours Children's Hospital, who was truly treating the sickest of the sick kids. Again, this is 2021, children were not eligible for the vaccine. There's great uncertainty as to the future of COVID-19, the future of these sick children, and that interest is important and matters. It's different than the UPS store down the street.
Was your client able to establish an undue burden, though, without looking at all at this employee's responsibilities? What if his job was to refill the vending machines?
Sure,
Okay, so
so
he's gone, the only burden is somebody might run out of M&Ms. Is there any world in which you could say there would be a hardship from that employee being gone for a couple of weeks?
well, I'm not sure that anyone at Nemours has that exact job responsibility. I appreciate the hypothetical. I think here, what Nemours was primarily concerned with, right, was the running, the overall staffing and operation of the hospital. For someone like Mr. Marin, he couldn't do his job remotely, that's important, right? And the record is clear, the testimony was clear, that Nemours was struggling in its operations. It was struggling to.
Was there any record they were struggling in their ability to repair HVACs, counsel?
There was no specific testimony as to the
That's my
HVAC
point.
department.
Nemours specifically, on its own, declined to examine any individual circumstances in terms of hardship related to these individuals. So you can dismiss the hypothetical. I think that means you don't have a response to it, frankly. I'm taking that, I think the failure to answer the hypothetical I find very telling. There are many jobs that would produce no hardship of any kind for someone to be there, for someone to be gone. In this case, you had an HVAC guy. Now, I agree, maybe there's circumstances in which an HVAC guy being gone, right? Maybe these are HEPA filters and they, they have to be constantly replaced for kids with lung issues. And if they don't, the kids could get an infection. He's the only HVAC guy. Like, you could imagine a situation in which that's an enormous undue hardship, an enormous hardship. You could also imagine a situation, there are 6 HVAC guys. They do routine maintenance. It would be no big deal if that maintenance waited for 2 weeks. It wouldn't affect Nemours at all. And your client not just wholly failed to establish any hardship on him on a specific basis, failed to even look. I mean, by their own admission, we did not examine whether it would be a hardship for him to be gone. And that was your client's position, that we did not look at the effect of him leaving.
Nemours, did Your Honor consider the cumulative undue hardship, right?
That's my point. I'm talking about individual undue hardship. I agree. They say they looked at the cumulative and they offered some kind of platitudes of we think it would be hard, right? There were no numbers about how many employees would be gone. There was no information about what it would take to cover them. There was obviously no cost information, but they did say, we think it'd be hard if we had a bunch of employees missing. But on an individual basis, they not just failed to establish, they specifically said, we're not gonna look at individuals, right? That was we're not gonna look at this on an individual basis. So answer the hypothetical, okay? Don't avoid the hypothetical. The vending machine refill guy,
Sure.
he's out. Is there any hardship to you?
So there's undue hardship associated with any significant number of employees, regardless of their job duties and responsibilities, being out for a significant amount of time.
Why?
And there was data on the record.
Why? So, all right, no, so all the vending refill guys are out. Every single one. You have no vending refill guys. The M&Ms are gone. People are banging on the glass. Like, it's pandemonium. What's the hardship of all the vending machine refill guys being gone?
It's the cumulative hardship of large groups of employees. These were not individual one-off requests.
If I can interject, it seems to me that you have 4, and maybe it's more, you'll change my mind if you say that there's a 5th or a 6th, but it seems to me that there's 4 ways that Nemours could show undue hardship in this case. Collective loss of employees, meaning you have lost all the M&M, vending machine employees, or whatever function that they serve, all the HVAC employees. 2, loss because of one employee, and this is the pediatric neurosurgeon versus vending replacement employee, hypothetical. And then you've got 2 others. You've got the potential risk of that employee not affecting Nemours because they're gone, but affecting Nemours because they're there and they have COVID. And that can be 3, the third one, employee-to-employee infection, if your vending machine guy infects your pediatric neurosurgeon, or 4, your vending machine guy, for whatever reason, infects your kid and kills the kid with cancer. Which of these, is it just 4? And then walk through and let me know where the undue burden is on Nemours in those different categories.
So just to make sure I understand Your Honor's question, are you asking, do I think there are just 4 types of undue hardship that
Let's start
Nemours
there.
would show?
Yeah, let's start there, and then if we can isolate it to those types of hardships, then I'm interested, I think the panel's interested in what competent substantial evidence supports those particular undue hardships.
Sure. I think speaking broadly, there are many more areas that Nemours could show undue hardship. Again, sort of the context of the business matters. There's established case law out there specifically in the context of vaccines, indicating that with healthcare providers, even just an overall distrust in your organization by patients and their family can be undue hardship. To think this hospital does not have a sufficient number of vaccinated employees. I think speaking specifically to the 4 that you mentioned and to the evidence on the record, there is evidence that at the time that Nemours made the decision to implement the mandatory vaccination policy, and this is one of the driving forces really behind that decision, 80% of employees who were absent from work due to COVID were unvaccinated. And again, when those employees were absent, they were out for at least 14 days. That was the mandatory quarantine, even if you were asymptomatic and you just tested
Does
positive.
the record say how many employees that was?
That is not in the record, no.
Okay. So that could be 80% of 4 or 80% of 5 people?
But it was significant enough, and there is testimony in the record that the absences were impacting the operation of the hospital.
Can we make anything out of the fact that 170 employees were let go and 500 were hired as it relates to the state of the hospital system at the time in the summer of 2021?
I think you can make out that it was fortuitous and lucky that they were able to fill those gaps at the time. I don't know that there's much legal impact to this case here, but they were thankful to fill the spots, obviously.
Let me ask about the third and fourth, which is the chance of any employee with COVID, or in this particular situation, an employee with COVID who goes into patient rooms. I think you heard Judge Mize's question to your colleague in the earlier one about it being hypothetical or speculative. You've got the testimony comes from Dr. Alexander. He talks about his generalized concern. Is his concern hypothetical or is his concern grounded in something?
So I think that his concern was grounded in common sense. Thankfully, I will say, the numbers bore out that there was limited transmission in the hospital because the hospital was proactive about utilizing social distancing measures and masking. But of course, that fear is still there and very real, especially for patients and their
Counsel,
families.
that's all that you just said. The numbers said one thing. They had numbers saying there's no connection. Yet it was common sense to ignore the numbers and act based on fear that existed despite their numbers.
Well,
Does that strike you as common sense now for you to say that?
So they weren't acting against fear without numbers. Again, their primary concern was the staffing of the hospital,
Hold on,
something that the
counsel. You
records
literally
clear.
said the numbers didn't bear that out, but they still had a fear. That's your exact words.
And again, the case law has been clear that in a hospital setting, the overall perception by your patient base can quantify as an undue hardship.
Okay, so now you've completely changed the scenario, right? We're talking about transmission, and I asked you whether that made sense, and instead of answering on whether that concern made sense, you then went to people might have some kind of psychological fear over unvaccinated employees. That's a completely different issue than the one I asked.
Sure, although it is part of the undue hardship question. Ultimately, at the end of the day, there was limited transmission between patient to employee and employee to employee in the hospital. That Nemours does not dispute.
Is there concern about something in that scenario? And in case you can't tell, I'm struggling with whether that testimony is competent substantial evidence or not. Because we have law that suggests that competent substantial evidence isn't speculative or hypothetical. On the other hand, you have an expert in pediatric infectious diseases who's got expertise in epidemiology and vaccinology who says, I have this concern. And if this concern comes to being, then we're going to be on the front page of the paper for a dead kid and it's not going to be good for anybody. Help me understand whether that's competent substantial evidence.
Again, I think I'll go back to the line of cases that look specifically at the context of the type of employer, right? And that more deference needs to be shown when the business of the employer is the protection of human life, which again is what we're dealing with here. It's a special type of employer. And the case law both before and after DeGoff gives deference in those situations.
Counsel, is there a case that says that an employer in this specific healthcare context has to wait until someone actually dies in order to meet their burden of proof and undue hardship?
I'm certainly not aware of such a case, Your Honor, and would be surprised if one existed.
I would too.
Is the deference you're supposed to give so great that when the numbers say, this is not a concern, our own numbers show we don't need to worry about that, we're worried about it anyways in contravention to our own numbers? Does it support that level of deference?
Well, again, when it comes to the staffing numbers, those numbers are real and existed. When it comes to the in-hospital transmission number, again, I think it's more, the law does not require specific metrics or
But,
numerical
but
data.
does it allow them to draw a conclusion when they have specific metrics that's directly contrary to the metrics?
When it comes to ensuring the psychological safety of patients, and again, pediatric hospitals, so also their families, I believe, yes, they can.
Okay, so you said psychological to me, which I think kind of goes back to that original point is there was no actual, or at least our numbers showed no worry about actual transmission. We just thought patients might be afraid of unvaccinated employees being around. Is that the real fear? If it is, just say that. It's not, it wasn't actually about the vaccine.
Well, that was not the testimony is that is not the primary concern that Nemours had. It is certainly a concern.
Well, but when
and-
I questioned you on the numbers twice, rather than respond to the idea that their numbers said one thing and they concluded the opposite, both times, rather than address that, you shifted to, well, there's a psychological concern. It seems like rather than address the numbers, you want to shift to their psychological concern.
And I only do that, Your Honor, in the sense that that concern constitutes an undue hardship.
Okay,
The numbers aren't required.
okay, do you agree it doesn't support the undue hardship of actual transmission being a risk?
Agreed, Your Honor.
It's a separate issue.
Yes, agreed.
Yeah. The testimony about a concern about actual transmission, directly and completely contrary to your own numbers, correct?
That's correct, Your Honor.
Okay.
Well, counsel, maybe I'm confused on the testimony. Was the testimony that, did someone render a medical opinion and say, in my opinion, there is a 0 chance that COVID can be transmitted from an employee to a patient or vice versa? Or was the testimony, it hasn't happened yet?
The testimony was that we are very thankful that those numbers are low. But the concern, of course, and one of
So there was evidence that it had in fact happened.
yes, they were just low numbers. But of course, there was also testimony that
How
I don't recall specific numbers, Your Honor. There was also testimony that there were periods of mask shortages, that there were periods of testing shortages, and that there were other factors that could hypothetically impact those trends and those numbers.
So, especially with COVID, it is really hard not to exercise the benefit of hindsight. I think the law suggests or dictates that we have to put ourselves back in the position of the decision makers in the summer of 2021, which was the emergence of the Delta variant. Is that something that this panel could factor as it related to that as yet unsubstantiated concern of a kid getting sick into our decision-making process?
I mean, certainly, these are decisions that must be contextualized into the summer of 2021, and not hard to believe we're in 2025 now, but of course, that's a big part of this case and a big part of the decision-making. The undue hardship is decisions Nemours made then, not in 2025, how have things played out. That would be unworkable for employers who are having to make decisions every day.
So is a concern, so if you had data sitting here in 2025 that the level of transmission from unvaccinated employee to patient or to other employee was 0, it's fair to say that that would be a much stronger statistical statement than one that could be made during the summer of 2021.
Could you repeat the question, Your Honor? I'm sorry.
Yeah, so if your data now shows that it never, ever happened over the entire time of the COVID pandemic, is that different than Dr. Alexander's testimony of saying, I have this concern in the summer of 2021?
I don't think it affects the analysis. I think it's the information that everyone had at that time that informs the decision-making and ultimately the court's ruling.
Does the Florida Civil Rights Act apply differently during pandemics? Is there any type of exemption or extenuating circumstances provision?
It does not. I would just point your honors, of course, to the COVID-specific EEOC guidance, which is authoritative in this case and was tailored specifically to help employers make decisions with regards to COVID vaccines that were in keeping with Title VII and then, of course, the FCRA.
How do we, no.
Thank you.
Ma'am, I don't think we need rebuttal. Thank you. Everybody spoke for 25 minutes.
Okay,
so
I'm sorry.
Thank you.
Can I just share a couple of comments in rebuttal?
No rebuttal would mean,
All right, thank
by
you.
definition, no rebuttal.
All right, thank you.
Thank you, though, for asking, though.
Sorry.
You did a good job for your client by asking.
Thank you.